Hello, everybody. From Shihab Burke today, 6 o'clock Eastern Time. We have an exciting little topic to discuss. A big change in the law, Brian. How are you today?
I'm doing well. I'm excited. I'm going around shouting our topic from the rooftops to anybody who's willing to listen.
Okay,
Is
awesome.
is the
And
bottom line.
then, and then we're going to be taking questions after that.
Yeah.
But before we do that, we're going to talk about a change in the law. Probably people who don't practice law would not even think about what, even read it if it's in the paper. It has to do with the doctrine of.
Chevron deference.
Okay, what's that Chevron difference, Brian?
Well, Chevron refers to the name of a court case, where it's involving Chevron, the gas and oil company. I don't think they're in business anymore. They've probably been brought and sold, and brand no longer exists. But the bottom line is this: it's a Supreme Court case that lawyers learn about in law school. It's from 1984, I think, and it basically stands for this premise that when the government is regulating, there's sort of two rules for whether or not that regulation can stand up. If the regulation goes contrary to what the law that's written by Congress says, well, the regulation is not going to win. But if it's in an area of ambiguity, an area where the statute doesn't speak, essentially, as long as the court considers the regulations to be reasonable, permissible under the statute, that the agencies can regulate however they want, create the rules to enforce the law however they see fit. It's within their authority. That's it.
So let me see if I understand you on
Yeah.
this, Brian.
Yeah.
The Chevron difference is basically where courts gives an advantage to the government agencies' way to regulate. And if it is a 50-50, the government wins.
Yeah.
The plaintiff in a litigation case against the government, for example, in an immigration case, if they have a case that is 60-70%, they might have a chance, strong. If they have a case that is a close call, then the government wins. And that's why a lot of time people come to us and say, hey, I want to sue the government. My case is delayed. But I say, is your case delayed significantly? Is the law, did they break the law in an egregious way, or they break the law a little bit? Because if the government broke the law a little bit, you may not have a strong case. Why? Because of the Chevron difference.
Yeah.
Because the court, all what the government agency has to do is to come out and say, you know what? Here's why we did this.
Yeah.
Some kind of a reason.
We're experts. We know what we're talking about. Here's how this law has to be enforced, and defer to us because we're knowledgeable in whatever we're regulating, be it immigration or labor or you name it, any sort of spot where the government regulates. And the government regulates on tons of topics. Yeah. It's not just immigration, but yeah.
So basically, the U.S. Supreme Court said we've had enough because, as our partner Cheryl said, they gave them some protection. The courts gave the agency some protection, so they have some elbow room to work their very stressful day-to-day management of whatever responsibilities they have, and they took it to the bank.
Yeah,
they took it and run with it.
Yeah,
it's just like a few years ago when the H-1B law was overturned. And their memos were overturned, their policies were overturned because they just took it to an extreme.
Yep.
And they took it to the extreme for like 10 years. They broke the law on probably over, I'm going to have to say, 400,000 H-1B petitions.
Yeah, for
sure. They broke the law close to 500,000 times.
Yep. Yeah.
Until finally the court said, you can't do this anymore. Stop it.
Yeah, they were even outside their own regulations. I mean, there's a lot of that was policy related stuff.
So that with the Chevron deference, the Supreme Court said we're not going to let you do that anymore.
Yeah,
you're not going to have that protection.
We are not going to tip our hat. We are not going to tip our hat to you. We're not going to say, we appreciate your argument against the regulations, but the agency gets the deference to them. The Supreme Court said 40 years ago that as long as the agencies are being reasonable, they get to keep their rules.
Yeah.
And now that's gone, meaning the rules are more challengeable. If the rules are out there, if the rules don't comport with the law or they're not reasonable, they can be more easily challenged.
So
And
that get when we walk into the court,
mhm.
the agency is not on a pedestal anymore.
Yes,
They're not treated special.
yeah, the courts have now taken the power away from the agencies to determine what the law means, and now it's really up to the courts to decide what the law means. It is their classic role. That's one of the justifications of the Supreme Court of doing this. It's, and if you read, this is all comes about the Administrative Procedures Act, Sam. Administrative Procedures Act governs administrative agencies, and that's one of the things that came up in this case. Is the Administrative Procedures Act says that the courts are supposed to interpret what the agencies do and and answer questions about their authority, and the courts are taking back that power.
So one of the big one, and I haven't. I mean, obviously, we will find out in the coming months, and maybe a little bit longer than months, maybe a year or two. What's the impact of this U.S. Supreme Court decision? It could be massive. It could be narrow. We don't know.
Yeah,
Because courts and judges have been trained to give agencies special treatment.
sure.
And it may not be easy to shake that mindset that they have
Yeah.
going into the court. But it's going to be so. One of the things, for example, just in bringing this to earth, so people understand what we're talking
What
about.
does it mean for us in the
Yeah.
immigration
So, for
context
example,
potentially?
the big conversation about how to count visa numbers. Probably Congress. Probably, I haven't looked at whatever example we have requires deep analysis.
Yeah.
I don't believe Congress, from what I can tell, has spoken on the issue of how to apply this 140,000 green cards
Mhm.
for employment-based immigrants. Do you count these for every spouse and every child, or you count the 140,000 only for the applicant?
Well, I have to agree with you. This is a good one because we know the theory is it can be done by executive order, by executive power to change what that calculation is, meaning clearly all agencies are executive. USCIS or Department of State is an executive agency, meaning
So that supports the proposition that probably Congress hasn't spoken clearly on that.
how we count people for counting visas. Do we
And
count
this
the
law is
individual,
ambiguous.
or do we
Yeah.
count the family? Yeah.
So if somebody can go to court today after before the Chevron
They could always do it.
deference was removed, you walk into court and say, why are you counting spouses and children? And the agency would say, because this is how we feel.
This is how we feel. The law. Yeah, one of the
Congress intended.
Yeah.
And the judge says the Chevron deference, we have to give them a deference
Yeah.
because they gave an answer. Today, after this case, they can't do that. They have to, the judge has to say what really should be done, not what the agency thinks should be done.
Yeah.
So the chances of overturning something like this
increase. That's the bottom.
has increased.
If you're challenging government rules, you stand a better chance today than you did in the past. What does that? I mean, what does it look like practically, Sam? We talk about one case going. I guess maybe I'm going to answer this way. Sam, what's the downside? The downside is, and I have a scenario.
There's very little downside, in my opinion.
Oh yeah. Okay.
Except the fact that the Chevron doctrine has been entrenched so long, and for so long in judges' way of analyzing and thinking that it becomes probably they may not call it the Chevron deference, but they end up doing the same thing.
Well, it's not necessarily the end of the concept of deference. Deference. If the agency can prove that it's the agency can prove that they have the knowledge and they have a good logic behind its regulation. They still may basically plead their case to a court and say, well, okay, we're going to defer to you, but you can't just
on the
just rest on your
decoupling.
laurels.
Yeah, on the counting of the 140, there's absolutely if Congress is silent on this.
Yeah.
Okay. unless it says you count it for non-employment. It's called employment based.
Yeah.
And again, the devil is in the details, and you have to read the regulation. You have to go back to congressional intent and what the debate was. What was the discussion on the Congress before you got to read all that. We haven't read it. We're just talking as an example.
Yeah.
So if they cannot present a clear rationale, rather than we feel that Congress is what they wanted, if they cannot present that, they can lose on that.
Yeah. Yeah.
They can lose on that, and Congress will tell them, the court will tell them, an intelligent court will tell them, if we can find one, you go back to the drawing board, and you are applying the visas incorrectly.
Yeah. I mean,
Back to your question, what is the downside? So I have a second one for you. I want to
Okay.
hear you because you have your thoughts you have your own views because you're giving me that smirk, that smile. The one that I think might be we'll be dealing with is we're going to be dealing with some crazy decisions from courts because a lot of the issues are way over their head. Judges are overwhelmed, overloaded, and these are very complex legal issues. And a lot of times judges are not interested in reading more than 3 pages of law. And if you have to read the whole book to understand how immigration law works, they're going to say, no, I'm not doing that.
Yeah, I was going to pick up Kurzban's, our immigration law reference book, and show that it's literally that thick and across 2 volumes.
And it's a truncated, and that's
Yeah.
basically a truncated.
Yeah, you can only
version of the law.
find like 25% of your answers, in there for example. Plus, it's so yeah.
So exciting! I think it's going to open things wide open. I think we're going to find ourselves in court more often. What other examples, Brian? Just talking here. Does challenging approval delays becomes easier?
Well, in a courtroom scenario, the government is going to say, our policy for choosing to process these things, the way in which we choose to process them is reasonable. Defer to us. We're taking care of it, Judge. And I would say it potentially comes up there. I mean, more interesting to me, Sam, is there's that statute out there that says, you're supposed to. This is a favorite one that gets underneath my skin. You're supposed to process immigrant petitions in order of priority date, right? And there are people out there who know that people with priority dates later than them got green cards when they didn't. If you're doing these things out of order, shouldn't you have the right to sue to get these things, going? Obviously they can't hold everybody else's green card up for one person's, RFE or something like that. But there are people with priority dates. I'm dealing with people with 2012 priority dates who've been current for a while, and I know of people with 2014 priority dates that got approved. Those people, it seems like there should be that's an interpretive area where it seems that somebody should be able to sue to, when your priority date is current, process my case pursuant to the law. If you do process anybody who's after me, why? You're outside of the law and your policy is wrong.
What about filing fees?
Filing fees,
So they're assessing something called asylum fee, and they're not even embarrassed.
The H-1B
they're not even embarrassed that they're doing that.
The H-1B filing fee, for those who aren't aware, who haven't filed for a while, has gone up at least $300 per case for most, but more likely $600 for employers with private employers with over 25 or more employees. So H-1B filing fee increase for the explicit purpose of applying. It's an asylum fee related to the asylum program, and
And it's not only H-1Bs, by the way. I-140s.
Oh yeah, I-140s as well.
I-140s has an asylum surcharge in it, and it's like, why? Because we are going to take money from you so we can
do a better job with our asylum program.
Yeah, and that is, I mean.
Yeah, and
where's Congress telling people that they can do that?
And it's going to boil down to, what does the law say? And we haven't, again, all these issues that we're talking about require a deep dive into what the law says. But I'm sure somewhere it's going to say that USCIS can collect fees for the work it does, right?
You know who gets charged asylum fee to, Brian?
Who?
self-petitioners, EB1s.
Yep, they do. Yep.
EB1s,
I-140s, yeah.
I-140, you get hit with $300
Yeah.
asylum fee. If
Yeah.
you're less than 25 employees
Which
company,
you're
you get hit
self-petitioner, yeah,
300
yeah.
bucks, 600 bucks. And then for nonprofit, it's zero. So
Yep.
where's Congress advising them? This is all agency makeup.
Yep.
It's SHIT.
It's yeah. Yeah.
Right?
That's
It's all agency made up. So and
Yep.
where's the law? Where's Congress telling you, one, you can charge, two, you can not charge nonprofit.
Yeah.
Nonprofit. I mean, one thing I know about nonprofit.
They got plenty of money.
Oh my goodness,
Yeah.
the people that runs the nonprofits, they pay themselves $1 million salary, $2 million salary. It's nonprofit.
Yeah.
But there's a big. I mean, people
Yeah.
make a lot of money in the nonprofit. Why are they exempt?
Yeah, I mean, so basically it becomes an issue of they make rules all the time relating to filing fees, right? They publish rules to create filing fees. I'm certain that the law says they can charge fees, but the question becomes: is it reasonable for them to charge H-1B employers and I-140 petitioners fees relating to asylum, a totally different program?
I'll be curious to see whether Public Law 114-113
Oh yeah,
charging $4,000. I'm looking here at my cheat.
Well, that's a law though. That's a law. Public law.
Yeah, but does it say I think it does say in the regulation $4,000.
Well, yeah, but it's a public law, Sam. Public law. It's a law.
Yeah.
I
think that one is defensible.
Yeah,
but the asylum fee of $600.
Yeah.
I'll be interested.
Yeah. So
yeah.
So I'm going to explain the downside for a minute, I think. And I think it's very cool because I have for most of my career as an attorney been really kind of down about challenging anything in court. Not anything in court, but a lot of things in court because there's a good chance you're not going to win because, they'll defer to the agency. They have to be really far off the mark and there you go. Right? Fine. Now, the good thing about having like a stable regulatory state is your results are predictable often, right? You can look up the regulations and know that, those regulations are going to govern your case. And as long as the government's being honest about how they apply them, great, you're good. You win. You win or you lose by those regulations. You argue those regulations. And if you can show that you're in compliance with those regulations, you're going to win, right? Now, when everybody across the country is going to start suing on everything, regulations are going to be thrown out left and right. Additionally, they will be done on a regional basis. We are in the Southern District of Ohio, right? And in terms of federal judicial districts. So here in the Southern District of Ohio, if a court says, the H-1B filing fee rules here are wrong, right? Well, congratulations. In the Southern District of Ohio, you no longer have to pay, hypothetically, the asylum fee.
The $600.
Right? But the guy in the Northern District of Ohio, where they didn't make that call, does, right? And now imagine that on
chaos. Chaos
on tons of issues on every field of law. I mean, so first of all, we don't have to deal with immigration law. We don't have to deal with issues of these kind of issues that much. What are the rules in this district and with this appeal circuit in this region, essentially, because there's regulations from the government that will govern all those things, and we can just look to those, and they're uniform across the country, and except in very rare cases where there's policy issues that haven't been decided and they're being decided by the courts. And I guess, again, it's basically, you're right, disparate results potentially across the country, with the regulatory state being in constant flux because everybody's challenging it in court. And, instead of having to know one set of immigration rules, we have to know one set of immigration rules plus the variances for every appeal circuit or district court around the country. Disparate results, yeah. Chaos is the bottom line. Yeah, there are 96 federal courts. That sounds about right. About at least one.
I'll take your word for it, Brian.
I was reading about it. Somebody we know was doing commentary on it for an online article, and the problem is, it's not just that. It's every court can have a different view of the rules. And in Southern District of Ohio, they can say, "Yep, those fees are good." Northern District of Ohio, they can say, 100% those fees are good, and that becomes a problem for US. It becomes a massive problem for USCIS, Sam. You know, just in terms of how how they enforce their rules. They're barely capable of enforcing the rules they have right now, Sam. The one set, you know, let alone court orders from individual district courts or later appeals courts from around the country. It is absolutely exciting times. It's I guess, Sam, I'm going to kick it back
But
to you and ask you.
in
Go ahead.
simplifying this a little bit,
Sure.
it does give us as immigrants, our clients, it gives us a leverage.
Yep.
It gives us a little bit of a level playing field, a little bit. It gives the agency the pressure to stay on top of it and not stomp all over our right. It is a victory for us because we may be able to swing one or two major victories out of it, which can make a huge difference. For
Yep.
example, the I-140 counting of how they allocate visas. That can be, if there's a court that has the guts and it goes on appeal, that can be serious, positive thing for us. So, yeah. I mean, obviously, if you go to the DC court and challenge it, it has a national jurisdiction, so
Yeah.
it may not be chaos all the time. It
Well,
also, it may work out.
I guess you highlight you mentioned it's you are kind of contingent upon what kind of judge you get. Depending upon where you are in the country and who appointed that judge is sort of one of the great sort of challenges there. I mean, the dream of conservative politics is to sort of
But when,
dismantle the
but
regulatory state.
when you sue and say this is illegal, I think the agency is going to run around very quickly trying to approve your case and get your case off court, outside the court, which is good for you. So a lot of times it gives you leverage.
Sure.
So you can raise some basic questions. Say this law is, the agency is doing something really wrong here, which is affecting my case. They're going to say, just approve this guy and get him out of here. I want this case outside the court. I don't want this issue to be litigated. So it gives you a lot of leverage because a lot of the cases we take to court get resolved without a court decision. Now,
It's
some of
true.
them do go into a decision, but many, the majority don't. And that is victory for the individuals filing this lawsuit. It gives us a leg up in more negotiating
Sure.
power and room to get our client cases in court resolved quicker
Yeah.
for them.
Well, what might it
So-
encourage then? Because essentially, Sam, this is the dream of getting rid of Chevron Deference is to reduce the power of the regulatory state, reduce the power of federal agencies to go beyond what Congress says, and the deep state to impose its will beyond Congress to have that power.
Yes.
And basically, regulations. I mean, regulations. It doesn't mean the end of regulations, of course. I guess it means that regulations should, in theory, be drafted more narrowly and be closer to what Congress says. Now, there could be a result where Congress could be forced to act more. Basically, if Congress doesn't like what's
Congress might
happening,
act.
well, yeah, I know it should
Good luck.
motivate them, but they're so bad at acting.
They're
It's-
so
it's-
fat, with their own, intoxicated with their own power and their own self-serving. And that's an excellent pivot to taking people's question. Brian, it's 6:25 and it's time to take people's question. What do you think?
I think that we can do that. Sure.
All right.
So,
With that, what are the rules on the questions that we have here, Brian? Ask any question you want.
Yeah. I
There
prefer
we go.
softballs, but hard balls are good too. Any question you want, just keep in mind that we're only getting a tiny little bit of information out here, and we're not establishing an attorney-client relationship. We're giving general information about general queries. We would always encourage you to really seek immigration counsel of your own choosing. I know a lot of people here are in the employment-based audience. Find somebody who specializes in employment-based immigration. There's not that many of those, but we're out here. There's other people as well. There's plenty of good people who can tell you answer your questions and really, put you on the right track. But really, any attorney is going to need to really talk to you and spend some time with you to understand what's going on.
Yeah.
Is the bottom line there.
Yep.
So, Let's get to it. And it looks like Sky Limit has good news.
Okay.
So, hi, Sam and Brian. Finally, my I-526 got approved. Priority date December 2021. Visa bulletin filing date for EB5 is April 2022. My I-485 was filed in June 2022 with a WAC, Western Adjudication Center, California Service Center. And with the average process time there is 20 months, apparently. I buy it. Okay.
Congratulations.
Yeah. Does USCIS wait for final action date to be current to request medicals, or can they ask before also? EB5 unreserved India chart April 2022, chart A December 2020. So one, I guess, does USCIS they will treat your I-485 like any other I-485 is the bottom line. Your EB5 is special, but your I-485 is not fundamentally.
They can. I mean, to answer the question, they can ask earlier if they get their act together.
Yeah.
Yeah, absolutely. They can also ask by mistake, or they can ask when the priority date becomes current. Sometimes they get confused. They can ask at any time.
Yeah, I'm just thinking though. I see. Your priority date, your medical exams would be expired by this point, and obviously, if you're doing an EB5, you have somebody representing you, but it's never a bad conversation to basically ask them, hey, can I submit medical exams now to preempt this? I do love medical exams as an excuse to tell USCIS to approve your case at the time the priority date is current. That's a good time as well. When if you're going to be current in January 2025, you send your medical exams with a big old bright piece of paper that says, I'm current in January 2025, and give them a good excuse to put those medical exams to work. It's a matter of strategy, I guess. So, when should I expect Chart B dates to be final action dates? I know it's a guess, but when can I expect conditional green card realistically? Well, Sam, I hear you clicking on your keyboard. I presume you're looking at the visa bulletin right now, and I'm just navigating. What are your thoughts on when does EB5 of December 2021 become current? Well, I'm going to look in July.
I'm not as optimistic. I mean, that it's going to move this year. I had an opportunity to look at how much movement it's been making recently. Mm-hmm. And it hasn't been moving much, which is a disappointment.
Yeah, I mean, he's looking at the unreserved. Jesus, they're in April 2022 for India EB5 unreserved. And, those seem optimistic. I mean, there's a pretty big difference between it's December 21. It's about a year and a half difference between dates for filing and filing action date. So historically, they would say that there's an 8 to 10 month lead time on those where they expect it to be. I'm not so optimistic.
Well, I mean, here's the good news. Obviously, all chargeability is current.
What all chargeability for?
E5 unreserved.
EB5 unreserved for India? No, it's not.
All chargeability for.
Okay, yeah, okay, all right, I see. Rest of the world. Okay, yeah. Gotcha.
So I don't have a prediction on that, Brian, but you're right. I think your observation is right on the money. I think that window is all what we can go by.
Yeah.
And that window is.
This person that I mean, their filing date is their dates for filing is current, and I guess my bet is one can hope within the next fiscal year or two is the bottom line that they will
within the next fiscal year, I would say.
Yeah, I would. That's what they're saying. They're saying essentially by the dates for filing, because again, the whole point of dates for filing is, hey, we'll take your case now because we're hopeful that by the time that we're ready to approve your case, then we'll have a visa available for you. That's what it should. That's what it really is supposed to be tied to, the processing time of a green card. So there you go. Rod's channel has something for us. My friend is applying for N400. Her 2 children are also green card holders. Do her children need to apply for N400? or are they automatically become citizen when their mother gets citizenship certificate? A very fun question we don't usually get in this venue. Sam, do you care to or?
We can, yeah, it's a fun. Well, citizenship is one of these applications that's a happy application,
Yeah.
and typically the officer treats you well and they're happy.
Yeah.
The acquisition of citizenship by naturalization of parents is well established for
Yep.
a long time,
Yep.
and very generous.
Yeah.
If the children, I believe, below 18,
Yeah.
I believe, and if one of the parents become a U.S. citizen, they become a U.S. citizen
Yeah.
by
Well, what?
acquisition.
Yeah, I think
Yeah,
there's a requirement of them being in custody of that U.S. citizen adult. But yeah.
yeah,
Yeah.
they have to be in custody of the children.
Yeah.
Now, the dilemma that people face is proof.
Yeah.
Is proof of that.
Yeah.
And USCIS charged a ridiculous $1,300 or $1,400
Isn't that bad? I
to
think it's
give
getting
you a
565.
certificate of citizenship. Yeah, to give you a
It is.
certificate of citizenship, if I remember correctly.
I thought it was like $800. That's a
Oh, we're beyond $1,000 after they raise the fees. Look at that, Brian. If
application for
correct me if I'm
replacements.
wrong.
No, it's not. It's
No,
no,
no.
it's
Certificate of
it's,
citizenship in 600, I believe.
yeah, okay,
In
it's
600.
600. Yeah, that sounds about right. And 600 application for filing fee. Drum roll is now I got to go to the special filing fee page because they changed everything. Wow, you're right, Sam.
$1,300.
$1,385. Wowzers.
Worse than the naturalization application, and
Yeah.
there's nothing to do.
Yeah.
And how long it takes? A year,
Yeah.
8 months, or
I would
9 months.
believe that. Yeah.
9 months to
That is
get
rough.
one of these.
Well, what do you do instead of that, Sam? Huh? What do you do instead?
Well, you can file for a passport application.
Yeah.
It costs $260, and you can get it in 2 months or 3 months.
Yep.
And that's easy to do. I would prefer you do both.
I would agree with you because
Yeah, I would
I've been
prefer to do both.
party to those passport applications at the post office where if you come with them saying I just naturalized and these are my kids and they're citizens under the Child Citizenship Act, they're going to give you the dirtiest look on the planet because you've made their job a whole lot harder, and they don't. It's a pain in the butt to do a passport based upon that. That's for sure.
You're not there to please anybody.
Oh, you're not there to
do your
please
job, but
anybody.
you need to be organized. You need to know what you're doing.
Have you had people come to you and say the passport office, the post office didn't take my visa, my passport
Not only
application for my
that, but
kids?
the agency will send you back a rejection. So you have to fight a little bit, but you can get it. We've gotten it for our clients.
Yeah.
You can apply. You can bypass the N600 and get a passport, no problem.
But I have to agree with you. You have to file for that because as soon as the passport's lost, you have no evidence that you're kidding.
Yeah, especially 20 years later, 30 years later, after many years of good life, parents pass away, and all these evidence to support. Yeah.
Yeah, I had a consult on one of those about maybe 2-3 months ago. Somebody had entered the United States with their U.S. citizen parent in like the 1940s, right? And they were applying for a certificate of citizenship recently, and basically they couldn't prove that their father met the requirements to pass U.S. citizenship for them because his father had been dead since like the 1960s or something like that. And I said, guys, in theory, I have no doubt that your dad is a U.S. citizen, but right now proving it is the greatest challenge. If you get that citizenship, even if you lose that citizenship certificate in the future, it's always going to be in the government records. You can do a FOIA request or get a new copy of it or something like that. But it is obviously a good idea to do it. I'm 100% on the same page as you.
Well, I have a funnier story for you on that.
My story is not funny, Sam. My story is sad. This guy has no clue where he belongs.
This guy was 70 years old, came to me.
Yep.
And father U.S. citizen, mother Canadian citizen. Mm-hmm. And she was pregnant, and they couldn't find. They're living on the border, mm-hmm. and they couldn't find a hospital in the U.S. that's nearby, so they crossed to Canada. Had the child in Canada, and they came back.
Oh dear.
And improving citizenship was interesting. But maybe that's not exactly related to this specific
Oh
case where
yeah,
the parents are naturalized,
yeah,
but similar. But anyways, yeah, I think we've answered the question.
yeah, yeah. I mean, talk to an attorney, Raj, to make sure the requirements are met. But there are as Sam said at the beginning, there are well established rules for passing citizenship to children, and there you go.
Yeah,
But yeah, that filing fee is higher, significantly higher than the $600 plus higher. That's about $600 higher
it's
than.
almost double.
How is that? I guess they got to do an analysis to figure it out, but
What
they have,
analysis? $600?
I don't know. You got to make sure the kids are in the physical custody of the parents, and yeah, okay, it's pretty lousy, Sam.
Yeah,
You've convinced me.
agree.
Yeah.
Yep. All
So
right.
from Coach Ram, AP renewal applied in May 2024. I had to travel while it was pending. Current AP expired. I returned and reapplied for renewal again. This time I had travel on emergency. Now they approved the first renewal, and the other they issued RFE while I was out of the country. Now I'm in the United States. Will respond to the RFE, voids the application, no matter what, or approvable. This, for me, Sam, falls in the category of I'm confused and I'm not sure I have enough information here.
Well, I mean, basically, he left the country, and so once you go back to the previous
Sure, yeah.
one so AP renewal had to travel while it was pending. Um,
Hey, Sam, I got
so
a good
that one,
I
that
got a good
one,
a good Chevron difference issue. Remember how basically how for the longest time they wouldn't care if you traveled with a pending advanced parole, and then suddenly overnight they would start denying that. Um, if you ever wanted to bundle all those applications together
right,
and sue,
yeah.
there you go.
Well, not
Um,
only that, but also they're also conflicted,
yeah, yeah.
and there's no good rationale one way or the other.
Well, again, we have to see what the law says, but it seems like again, like
Yeah.
back to Chevron difference. It's everything that irritates me about immigration law makes me want to go read what the statute says and see whether it's worth taking it to court. You know,
Well, he traveled while it's pending. What's the rule on that, Brian? Let's
oh,
simplify
if
this.
it's current AP expired and you travel while it's pending, it means they should by their policy deny that AP.
So he expired while he's outside the U.S.
I had to travel while it was pending, so he had. It sounds like he had no AP, right? Then traveled
AP
while his
renewal
yes.
applied
But
in
it
May
says current
2024.
AP expired.
I had to travel while it was pending. The
Hmm.
renewal was pending. Okay.
Yeah,
So he had the current AP expired.
that's what I'm hanging on. Yeah.
Yeah. So you're saying when did it expire? Did it expire while you're outside the U.S. or did it expire while you're inside the U.S.?
This is such a great question to ask, Sam. When we're speaking about deference and what does something mean, I was interpreting that to mean I had no current AP. I left the United States with my AP pending, and then I returned. That's how I was interpreting it.
Yeah. And that's why we cannot really give advice on
Yeah.
anything because, but the general rule is you really need to have a lawyer to look at.
Yeah.
Yeah,
I think.
there's not enough information, but obviously I was reading it differently because I was hanging my hat on the renewal word after AP.
Yeah.
I assumed it was
Renewal applies.
valid.
You have an active one. Yeah. I get you. Yeah.
So yeah,
So I guess the general answer is it's still their policy. If you don't you would agree that if you don't have a valid AP and you leave the United States with a pending application,
yeah.
you're
And if
they're
you have
gonna
a renewal and pending, and then you leave, and then
yeah.
while the AP expired while you're outside the U.S.,
Yeah.
is the renewal valid or not?
I don't know. It's a good question.
Yeah.
Yeah.
Not offhand, I can't answer that question
Yeah.
either.
Yeah.
Because USCIS has not published policies on that.
Yeah. Well, right here, Sam, I like the system we have, the software that we use to do this streaming, but I think I see some potential hole in it because I'm seeing part 2 of somebody's question and not seeing part 1, but we'll try our best. And
It
this
happens.
relates to our topic. USCIS relates to Chevron Deference clear. USCIS has too much power. They can slow down adjudication and waste visas, and then retrogress the priority dates. How is this fair? They shouldn't be allowed to throw out the visas. Now, I would note that that's under the law. The visas get thrown out. The way the law is
Well,
written,
but it's not under the law to waste visas.
it is unused visas. Well, it is under the law. Unused visas they disappear. But the policy by which they process their cases to that allows that to happen is what can be questioned, I would argue. But fundamentally, Sam, so many of these issues are going to become these cases are going to become issues of money. You know, well, you're saying you don't have the authority to just sit there on my visa and not act within the period, and the government's going to say, well, we don't have the money and the resources to take care of that.
You collected the money
Yeah,
before you took my case,
yeah,
and you told me on that year that that money is appropriate for for them to review the case, but they
yeah,
didn't review the case,
yeah.
and they kept the money, and they
So
wasted the visa.
okay, well, how does a court case play out, Sam? Approve
Well,
my case.
well, no, I think I am just. I don't think it's a Chevron question on this case. This is not a Chevron related
I
issue.
don't think it's a great Chevron question because again, the law says those
However,
visas
it's a
go away.
painful issue.
Yeah,
You took the money. You knew you had to do it. Then you didn't do it.
yeah. Now,
There's no penalty for incompetence, for failing to meet deadlines. Nobody gets fired. Nobody get reprimanded. Um,
yeah, no,
and there are no consequences.
that is
Uh,
true in government.
yeah,
Sometimes the only time there's really a reckoning is if you piss somebody off so badly that they can bring the director of the agency before Congress to get a tongue lashing, and that doesn't even really do much either. You
yeah,
know,
yeah.
you know. Um, the next question is a great one. Something I was thinking about when I thought about the end of Chevron deference, and I hadn't thought about this court scenario for a while. From Empire, the same groups that previously challenged H4 EAD has stated that with Chevron gone, they will be challenging it once more, along with OPT STEM and the case against DACA. DACA just got stronger. Um, what are their chances in litigation if they find a friendly federal district court judge, especially with the H4 EAD, because Chevron played a big role in that case? What was that case? Is that Save Our Jobs USA? I think it was.
Yeah.
I think it
Well,
was.
he's right on the money.
Yeah.
The sword cuts both ways.
Yeah.
And with H4 EAD, if it's invalidated, that is going to be really hurtful
Yeah.
for people.
It will.
Um,
It will. I will drastically transform. Not. I mean, how many people do you think are on H4 with an EAD right now, Sam?
I don't know, but enough to make people make the U.S. not an attractive place to come in.
Yeah, this is a conversation we always had was that
Yeah, I have to
every
agree. Now, whether or not the concept of res judicata,
yeah.
the
Yeah.
concept of but the res judicata is only a criminal concept, isn't it?
Yeah, I believe so. But there's still stare decisis, Sam. It's rely on prior precedent, and part of the case, it's Loper Bright is the name of the case, I think it is, that overturns Chevron deference. It says we still leave our cases based upon Chevron deference intact. So, it doesn't overturn everything out there. But again, everything seems fair game to me. And that is the scary part.
I know immigration consequences has a res judicata concept. As a matter of fact, I won a res judicata argument um, um, on a deportation case. When I used to do deportation, I don't do deportation anymore. On the appellate level, you got thrown out because of res judicata, that you cannot bring back a case, the same case, and try it under a different argument. But I don't know. This is immigration too, so it'll be interesting whether or not they have the right to bring back the same case one more time. Although,
all you need is another plaintiff, though, right?
Yeah, I think so.
I mean, it's a different case with a different plaintiff. So I guess, for me, that again, Empire. That's the exact thing that came to mind. The regular H4 EAD. I guess it's a matter of what does the law say. More closer examination. That's what we're really kind of looking at in the future. Is more closer examination of what legal authority that Congress has delegated. Obviously, the U.S. there's a right to regulate who's allowed to work in the United States in terms of foreign nationals in there. But
And the new Biden law, executive order that just is being announced and has they haven't even released anything yet.
Yeah.
That can also be
Ooh,
now
that's a great point. Yeah.
take advantage of the Chevron deference being gone and say, where's that coming
Yeah.
from, Mr. President of the United States?
They're about to put out a regulation or a policy on the subject of, people. What does humanitarian concerns mean for people who have been in the United States for 10 years and are married to a U.S. citizen as of June 17th, 2024? And it's basically, is
Challenging
that
that would be
reasonable?
extremely unpopular, though. I mean, these are affecting U.S. citizen
Uh,
children, U.S. citizen spouses.
well,
So politically, but who cares about politics?
judges don't care about politics. Judges are appointed. Judges are appointed to. They're appointed for life to. To do their job.
The right thing.
Do what the law says, and
Yeah.
that's. I think there's a lot of regulations really up on the chopping block because of this change. And well, there you go. Again, Sam, what was I think that as soon that there are so many, just over the last couple of days, there have to be so many potential court cases in the works on with the with saying now that we say adios to Chevron deference, just tons of them. Because on both sides, I could imagine a court case hypothetically. Again, you got to read the law devils and the details about going after the counting of visas, but I could also imagine the one that kills the H4 EAD as well. And I have no doubt that they would be going after the H4 EAD again. They put some serious effort into that case. And
Hmm.
well, we'll definitely have more to talk about. In our YouTube sessions here, Sam, because there will be, in theory, immigration. Where does immigration news come from, Sam? It comes from USCIS normally. It comes from the Department of State. It can come from one of 96 federal courts around the country
Right.
at this point, in
It'll be
theory.
interesting to see.
Yeah.
All right, let's take a hurry.
Hurry. Well, I am on H-1B with pending I-485. AP recently approved till 2028. While my previous AP was pending for a long time, I've applied for another AP extension in January 2024. Can I use approved AP to travel out of the country? Well,
If you have an approved advanced parole,
yep.
that approved advanced parole allows you to travel outside the country and return. The AP doesn't help you to leave the U.S.
Yeah.
It helps you to enter the U.S.
Yeah.
So you don't need AP to travel out of the country. You need AP to travel back into the country.
Yeah.
The fact that you have another pending advanced parole does not invalidate the one you have.
Well, I got to add another layer. I got to add an attorney qualification. Just having an advanced parole does not guarantee your entrance to the United States. If there's some sort of underlying inadmissibility there, don't. People like having advanced paroles because it's you don't have to go for a visa and you feel good. You don't have to worry about getting told no at stamping, for example. But it doesn't fix any fundamental immigration eligibilities that you have.
I haven't seen any problem with advanced parole being
Me either.
approved. Yeah, I haven't
Me
seen
either.
it, but yeah, I think just telling people it's not guaranteed is very fair.
Yeah, my scenario is hypothetical. Hypothetical. It's possible, but you would have to have some customs officer with some really great information there to say, ooh, we don't think you're. It's really hard to get you. And being admissible in advanced parole, the only thing do you have a pending green card? Yeah, if you have a pending green card, we should admit you, and they're probably not going to have information about some other immigration, maybe criminal stuff. Talk to an immigration lawyer if you have a criminal issue. They come up with travel, that's for sure.
Yep.
Yeah. So Sam, Fatima.
Fatima Rafi.
Yeah.
All right, priority date is, well, I'm going to say in the month of October, on the 31st of that month in the year 2016.
Mm-hmm.
DQ 12/22/2022.
We have ourselves a family-based question, Sam.
Mhm.
Yeah.
F2B, all chargeability from Nairobi, Kenya. When to expect interview appointment letter waiting since January 7, uh, DQ documentally qualified from January 7, 7 months for now. Okay, so a long time. Been waiting
Yeah.
for a long time.
So
Um,
F2B,
so,
go ahead.
yeah, Nairobi, Kenya is, and other embassies are overwhelmed. Family cases, if they say the documentary qualified and they're not moving on them, you are going to be one of thousands of people who are experiencing the same problem right now.
Mhm.
And many of our clients are finding remedy by doing what, Brian?
Suing in a writ of mandamus and under the Administrative Procedures Act in federal court.
And we are doing that on a consistent basis for our clients, and we're getting results for them.
Yep. Yep.
So if your wait is 6, 7 months, no. I got people coming to me waiting 2 years,
Yeah.
two and a
I
half years.
My
Uh,
one that I'm working on began the sponsorship process, I believe, in 2019. She filed for her husband in 2019. Yeah, rough.
yeah, and if they're not able to get, I'm not speaking about Nairobi because there's 270 different
I'll
consulates
speak about
across the
Nairobi.
U.S. Yeah,
It's slow. It's really slow. Anybody who I've talked to, I don't has I've talked to plenty of people about. I think that I'm not sure the one I have the mandamus action going right now. I
is
believe is
it
out of.
Kenya?
I believe it is. I can look it up right now because I'm curious. I mean, every case is different, and they believe all their delays are legitimate, of course. But I have heard nothing but slow out of the consulates in Africa. Is the bottom line.
And one of the things that we see as Brian look is you sue them and the case has been pending documentarily qualified for 2 years
Hmm.
and you sue them and they say, oh, can you please give us 60 days or 90 days so we can do background check.
Hmm.
They
Hmm.
haven't done nothing.
Yeah.
They haven't touched the case, which means this poor soul that we would be representing, these clients that we represent, they haven't touched their cases.
Yeah.
And trust me, in that room where they went in and grabbed my client's case to process, you're laughing. It's Nairobi.
It is Nairobi, the case I'm working on right now. NVC got the case in July of 2020, and basically it took them. This is again a couple years ago. Um, Documentarily qualified in January 5th, 2021. They did not interview the guy until April 2022. So over
And then did nothing after that.
and 2 years now. They interviewed in April 2022, and well, there's a reason why we're suing the government for this. And again, just last week they said, "Oh, we want to keep on looking at this. We don't want to waste the time on litigation. Can you give us more time?" And again, they interviewed this guy 2 years ago. They can't make a decision in 2 years on that. It's rough. Yeah.
Yeah, because it's sitting on piles of papers upon piles of papers upon piles of files. I have to go in that dusty room, dig it out, find it, and say, "Gee, wow, let's get going on this case." So yeah, it's hard. It's very difficult.
Well, I'm following the chat here. I see Fatima gave us a little bit of clarification with some news that doesn't surprise me and some news that I think requires some
Maybe one
clarification.
year and 7 months.
Yeah.
They say I have to check final action date, be current, but date for filing chart, I am current. Okay,
So
so maybe final action date is not current.
yes, so maybe I'll do a public service announcement here and explain the difference. So the final action date chart is when you're eligible. They are eligible to give you a green card. Under the law, they cannot change that. So I would suspect, Fatima, if your spouse is I guess I would suspect that you F2B. I'm sorry, you're not even a spouse. You are, I think it's a unmarried sons and daughter category. Your final action date must be. The bottom line is your final action date must be current in order for them to issue you a visa. If your final action date is not current, uh, the consulate is plenty slow on plenty of things, but they cannot go any faster if your final action date is current. Under the law, they have to have a visa available for you in order to issue a visa. So if they're telling you to go back to and look at the dates for filing and wait for the final action, I would say it seems likely that your priority date is not yet current. Is my answer there? Yeah. So good for you, Sam.
Yeah, I'll take it. All
Okay,
right. So,
Coach Ron here we have is my next one.
okay.
I think is giving us clarification. What is his last set of questions here? I traveled out of the U.S. while my AP is expired and renewal pending. I returned and then sent a withdrawal request to USCIS. Oh, okay. So that makes sense.
Okay.
We
That
applied.
doesn't change. That doesn't change the answer.
Yeah.
You really need that. I really need all these dates laid out for me
Yeah.
with the documents so I can say what to do.
Okay. So I reapplied for renewal again the second time and again had to travel for a family emergency. And now they approved the first renewal and sent the RFE for the second renewal request when I was out of the U.S. I'm now back in the U.S. Will respond to the RFE, void the application, or continue processing. Ooh, that's a real complex question because it sounds to me like the one they approved may have been contrary to their policy.
That's what
Right.
I'm thinking.
Yeah.
I
And
need all the paperwork. There's no way we can respond. I think what you need really is an attorney to look at this card.
yeah,
I mean,
yeah,
you need it laid out because this thing is going to turn on minor things.
yeah,
And then you're going to say, you know what, this is worth it. This is not worth it. Not only is it responding to the RFE, but also, how complicated the issue is and the cost versus the reward, likelihood of success. So
yeah,
get an attorney because it's going to turn on minor dates here or there.
yeah, yeah. I mean, that's.
Any opinion, Brian?
I mean, the fundamental nightmare scenario is, in one hand, you have a authentic advanced parole document issued by the government, right? But all it takes is, a guy at the border to say, "Hey, that was issued contrary to policy," and you're in trouble.
Yeah. I would, if in fact it is issued in error, I would absolutely not use it.
Yeah, that's where
Because the consequence is more severe. So
yes.
if you have an H-1B and you have a stamp and you have an advanced parole and you can present the advanced parole and they say, no, it's issued there. Well, here's my H-1B stamp.
Yeah.
But if you don't have an H-1B stamp and you're relying on this advanced parole and they say, oh no, this advanced parole is invalid, that can undo your adjustment.
Yeah.
And therefore, we have to be very careful touching something like this and advising COT on what to do and how to respond to the RFE.
Yeah.
All right. So coming on the hour, I think we may have one or two more questions.
Yeah, I think we'll be able to get to everybody here because we'll have this one and maybe we'll get that one after it. So from Raj channel, any prediction for EB2 rest of the world for August visa bulletin? My priority date is March 15th, 2023, and you just need the bulletin to move by 1 week. Thank you so much. Well, let's engage in some finger crossing on behalf of Raj here. I'm giving him 2. That's one from Sam. That's 3. That's a pretty good value there. Let me see. I'm pretty sure they commented this on the end of the July visa bulletin, right? Actually, no, they didn't. Maybe they was on the June visa bulletin. They commented.
But it doesn't mean anything.
Yeah.
We are in July.
Sure.
Next month, September. 2 months of September is really the next jump.
Yeah.
Realistically.
Well, yeah.
It can move 1 week.
It's not crazy, but I'm going to remind everybody what they said on the June visa bulletin, and this is how we got to where we are right now. High demand in the employment second category will most likely necessitate retrogression of the worldwide final action date, including Mexico and Philippines, the next month to hold number use of the maximum allowed under the fiscal year 2024 annual limit. I mean, we got that retrogression, as I recall. And I'd say, if I were a betting guy, and I'm a pretty conservative guy, I'd say October's not that far away.
Yeah. You should have luck by October. Let's put it that way.
Yeah, I'd be putting my money on my chips on the October area. That's for sure.
Yep.
One last question, Sam, because there's one last question left. Sound okay?
Yeah.
Okay, a good one on topic with what we were talking about earlier. With Chevron Deference gone, is it possible that someone could now question the interpretation released sometime, I think, in 2021 about the 7% per country cap, per country limitation. I thought that's written into the law. Is it not?
Well, that's a very good question. I would be interested to see what that's in the statute, but the 7%, it does not make any sense, obviously. It's one of the stupidest laws. I was looking at San Marino.
Mm-hmm.
It's a small country in the middle of Italy.
Yeah.
In the middle of Italy, it's on a mountain. They said, we're a different country.
Yep.
And the Italians said, you become a different country. I don't care. So they're Italians, but they're a different country. 33,000 people.
Yep.
33,000 population.
Yeah. Infinite visas for those guys, right?
7%. They get 7%.
They get nothing.
And China,
yeah.
which is 1 billion plus,
Yep.
gets 7% of
Yep.
the 140,000.
Yeah.
And San Marino, 33,000, gets 7%.
Yeah.
India gets 7%. It doesn't make any sense.
I guess the big thing to sort of come back to where we started, that Chevron deference was about what does the statute say, and if the statute says something, well, that's what you got to go by what the statute says, and everything else, if Chevron deference says if what their agency says is reasonable, well, we're going to defer. Now, there's no more deference to the agency anymore. But again, the first step of the analysis on this one is something I have to think about. I don't recall.
Well, the first question is, what did Congress say?
Yeah, what do the statutes
Did Congress say 7%, or Congress says equally divided, use some broad language?
Yeah.
And then
That's a
the
great
regulation came down and said it's 7%.
Yeah.
So if the latter, if that's what happened,
Yeah.
if the regulation came out with the 7%, which doesn't make any sense, potentially you can challenge it. But
Yeah.
if it's in the it's in the statute, built in the statute, which is I suspect it is, then yeah, there's no challenge.
Yeah, that's where I'm at
No
with that
sense.
one.
Yeah.
We're also at, Sam, is 7:03 p.m., which means I think we might be done here today.
Yep, sounds good. Thank you guys for listening to us. Hopefully it was helpful. Come back 6:00 Eastern time on Monday, and we will do this one more time. Take care. From Shihab Burke, Attorney Brian,